CR 2024-2204 for sentencing, Gabriel Perkins. We're joined by Counsel Neal for the state, Mr. Bowles, and Mr. Stavinsky for the defendant. And the court has prepared for today's sentencing by reviewing the pre-sentence materials. Mr. Perkins, have you had that opportunity as well?
Yes, Your Honor.
And as you did so, did you see anything that needed clarification or correction?
No.
May I then rely upon the contents of the report for sentencing?
Yes, Your Honor.
Okay, thank you. And the court received yesterday the addendum that included just a short note. Did the parties receive that as well?
Yes, Your Honor.
Okay. And other than that, if there were other letters or things, I would share with you that I have not yet received it, the PSI and then the addendum. How we will proceed through today's sentencing is I'll turn to the state and ask if there are to be any witnesses and or any impact statements. And then I'll ask that same question of the defense. Why don't we do that? Does the state have any witnesses?
We have 3 impact statements, but no witnesses.
Okay. Does the defense have any witnesses?
No, Your Honor.
Very, very well. Then how we will proceed is I'll invite the state to invite those impact statements up one at a time. I'll invite them to sit at the table there. We'll hear those, and then from that point we'll turn back to the state for its sentencing recommendation, and then turn to your attorney, Mr. Perkins. If the state has any concluding rebuttal remarks, I'll permit that, and then following those, I'll ask you if you're interested in making a statement, okay? All right, so Mr. Neal, who would be the first individual to come forward?
Who's the father?
All right. Good morning, sir. If you'll have a seat there, and I think that microphone's situated properly to be heard. You
Yep.
may begin.
I'm Todd Barber. I'm Alex's father. My impact statement is that the death of Alex Barber has been devastating. From laying in a body bag to having his brain and organs removed at an autopsy to a funeral and a cremation. It has been very disturbing mentally and physically. It has affected our family, our friends, and many people in the community. I don't know how or where to begin on how much pain, devastation, sorrow this tragedy has created. You could say it has been a nightmare of the worst kind. I've been trying to let go and move on, but I find it is almost impossible. I had a lot of plans for the future and was planning on making a lot of memories, but that has been taken away. And as time goes on, Alex's name and memory just become a picture, a headstone, a memorial chair. And yet we have a young man here that has his whole life ahead of him. Granted, he will have to pay society for his crime, but he will be able to eventually be wed, have children, and live out the rest of his life. Alex will never be given that opportunity in the future, for he no longer walks this earth. His murder was labeled a homicide, 2nd degree. His death was not pleasant or peaceful. He can be told circumstances or a version of this incident, but nothing speaks as loudly as watching the video to get the real effect of what took place and the role that Gabriel played in it. It is absolutely horrific to witness the extreme measure that Gabriel went to as he took control of the scene and the carnage he left on the blacktop as he fled the scene. Gabriel has pled guilty to all charges, and I believe if there had been any cartridges left in the gun, that he would have used them, killing Devin and putting another slug into Alex. He knows what he done, I know what he done, and God knows what he done. God gave man free will, and that is why we have courts and laws. People have to answer for their crimes and their actions. I believe we're at a turning point in the world where a firmer hand is needed in sentencing for some of these horrendous crimes. Leniency is not sending the right message, especially when it has to do with a crime involving a gun. So, thank you for your time.
Your Honor, how are you?
Thank you. You'll-
I'm Chris Stewart. Alex Barber was my brother. I didn't write anything down. I wanted to just kind of go off my own feelings, and Todd did a pretty good job there, naming a lot of things I was going to say. But this has been really devastating for me, for my kids, for my mother, who actually has recently passed away last year from a broken heart. So I kind of speak for her too. She couldn't deal with the fact of losing her son, and you know, it's been extremely difficult, and I can't express how upset, angry, sad, the sorrow I feel. Did bring Alex with us today, so he's here in spirit, and I got a picture of him. But I hope the defendant has a really bad time in the time that he has to do, and it's not easy for him, and that's all I gotta say.
Good morning, my name is Annalisa, and I am Alex's sister. I'm here today to read a statement from her mother, Dorothy Barber, who unfortunately couldn't live in a world without Alex. He was her caregiver, her soulmate, and her youngest child. Unfortunately, Dorothy passed away December 28th of a broken heart, which leads me to deliver her message to you today. She says, "He is a monster. I hope he gets the death penalty. He has no right to take my son's life and to break my heart forever. I have no respect for him. Jail is where he belongs. He killed me too. I look for Alex every day. Dorothy." On a personal note, I want you to know that I do forgive him. Not because he deserves it, but because I need the peace that forgiveness will bring in my life. 15 years is not enough for what he has taken from us. February 12th tragically changed the lives of so many people, and I hope that over the course of his sentence that he can come to understand that every action has a consequence. I hope that he is reminded every day of the pain and sadness and loss that he has caused his family and ours. I hope that he will remember that, and that it will encourage him every day to do better and to be better. And I hope one day he will deserve my forgiveness. I want him to know that I will not spend one more minute thinking about him after today, and for the next 15 years I will focus on living 2 more lifetimes. One for the mother and one for the brother that he took from us.
Hi, Your Honor. I'm Devin Johnson. I'd like to say that night that it happened, everyone was out of control, but when Gabe pulled the gun on Alex, Alex was hovering over me and Colton, and he wasn't doing anything. He was literally hovering over me and Colton to save us from getting shot, and Gabe shot him over the head over nothing, and then he tried killing me. And I begged him like 3 times not to kill me, and he didn't because the gun jammed. So Alex took the last bullet, and then that's when he gets in his truck, and then I pull out my phone because that's the last moments of my life, and I start recording him, and he comes up for no reason and shoots me in my leg when I'm already shot in my back, laying on the ground, dying. Seeing Alex lay next to me, bleeding out, looking at me, and I see that every day, and I still don't understand why Gabe will do that. He won't even look me in Coleman in the eye today, at all. And I still don't know why he would do that to someone that didn't even do anything to you, and he was just hovering over us. And I'll just always remember Alex and Gabe. I don't think I could ever forgive you for coming up and shooting me in my leg when I did nothing to you. And I just will always remember Alex is a very good person, and he was the most courageous person ever. And Gabe, you're a coward.
That's it for the impact statements, Judge.
Thank you. The court will have some comments in response to what I've heard. I'll now turn to the state for its sentencing recommendation.
Your Honor, this the resolution here today is based on the ability of the victims and multiple victims it involved, being able to come together with a mediator, a retired judge, and reaching some form of agreement as to outcome. And today I don't intend any of my words to disturb that agreement. But as the as the prosecuting attorney in Bonneville County, I do believe that the community deserves to be heard on just what was a series of just profoundly stupid decisions that led us to this today. And to say that all of those decisions belong to this defendant would not be a fair statement. But it was clear that at certain points during this event, there was just a complete disconnect from the reality of what was the potential result of these activities. And I'm especially disturbed by any comments here about that folks on either side were acting in self-defense. This was a schoolyard. It was a prohibited area for firearms, period. There was no justification for those firearms to be in that parking lot of what is an academy, a Compass Academy. It's intended to be a place of education and somewhat sanctuary, and here these folks were using it as a kind of a wannabe gang fight. Something out of a movie or a stupid video game. And when these folks were lining up the cars to provide tactical advantage and checking weapons before the arrival of the other group, that is not over a wallet that was stolen by a teenager from another teenager. I mean, that the lack of understanding of the deadly consequences that were just around the corner is just staggering. And for that, there needs to be a consequence. And for that, there needs to be really an alarm into our community and the young people this age that apparently are so desensitized to the nature of this kind of threat that they can walk away having shot other individuals. And it wasn't one person, it was multiple, and multiple attempts. I mean, these people were, as the words that were just spoken, were out of control. And the consequences, the outcomes of their actions, I mean, we were blessed that only only one life was lost. But I want to talk about that first, and then we'll move on to what happened after that. So, whenever we talk about a crime that results in death, and I think that the victims and the state have tried to the extent possible understand the nature of these circumstances and how it affected what otherwise would be some reasonable judgment, perhaps. We understand that circumstances created by these young folks were actually restraining their good judgment and their control, and that led to deadly decisions. And again, we're fortunate that 2 people are in this courtroom who could have easily been added to that list. But as we start with Alex Barber, there is the effect on Alex himself. And normally when we talk about a lot of crimes, we can talk about the effect that they have on a victim. If something is stolen from somebody, that person has a loss. But why crimes involving the death of our fellow humans is so severe is because that's just the start. There's the ripple effect that comes with the death of someone that proceeds through their loved ones, through their family and friends, through students that were in school with them, through neighbors, through our community in general. This is not the kind of community we want Idaho Falls to be. That we have these kind of wannabe gang activities here that led to such horrific results. So we have this crime in and of itself that has this ripple effect on so many people. And then we have, after that, just a loss of control where Mr. Perkins shoots an individual lying on the pavement and then drives over another who is unconscious. Just a complete detachment from the danger that he was inflicting on these folks. Now, he wasn't alone. There are other individuals who also face charges and consequences hopefully come for them as well. But today we talk about Mr. Perkins, and I talk specifically about the attitude that the state expects from Mr. Perkins. We would expect him to understand how badly, how these decisions affected so many people. We expect that he would accept accountability, that he would admit just how poor his judgment and how unjustified his actions were. And going forward, we would certainly expect that he would behave better than those incidents that were reported while he was in jail. The consequences, we did note that there was an additional addendum that talked about him improving since April, but the idea that while in jail there were any incidents, and especially getting in a fight, occurred, really speaks loudly about his chances for success. And so the state makes these comments largely because it's in the interest of this defendant to understand the stakes as he goes into prison. His risk assessment is high. That's based on 8 different characteristics, and those reflect the risks that he currently has through these various factors. Those are going to affect his success, whether he's in prison or he's released on probation. And the bottom line is 17 years fixed is not a guarantee of release. And if he hopes that that's when he's going to be first considered for release, then the the behavior and the things that he does in prison, they better be model inmate conduct, because otherwise 17 years will be the start and not the completion. He has a total of 40 years. We expect him to be supervised and closely watched over, and a structure to be there to ensure our community is safe. And if he fails to follow the instructions in both environments, then he's going to stay in prison until he's an old man. And that's the best we can do at this stage, and that's the best that we can hope for as a criminal justice system, is that somebody will accept accountability, will be an example to others that this is going to have severe consequences if somebody else is foolish enough to completely disconnect from the reality of the type of danger that they were getting involved in. That there is somehow some kind of honor in these kind of activities, that somehow they were sticking up for somebody instead of using their brain and using their conversation to try to reach a compromise or a resolution, or to resolve a problem that was just too minor to be addressed in this way. So, given the various cases that have been all too frequently over the past couple of years, the state did believe that this was in the range of a consequence that was appropriate given the outcome. However, there's part of this outcome that is frankly within the control of the defendant. And if the attitude and the philosophy and his outlook on life don't change, well, then it'll be a much more severe than perhaps he believes it might be going into it. The state demands a change in attitude, a change in approach, and a change in outlook. Otherwise, our community is not safe. So there's an opportunity for this young man to prove himself. That is really a gift of the victims who allowed this kind of an agreement to go forward, even though I think most are a little bit discouraged that the charge was reduced. My belief as the prosecutor is that given the rather sudden activity that led to Alex's death, that this might be the appropriate outcome, and that's why the state agreed to it. But the consequence is there regardless of what those words mean. But in the big scheme of things, when we talk about murder, we talk about somebody who makes a decision and goes to take someone's life. In this case, manslaughter refers to a series of bad choices. And they started well before that night. They started when this individual started to develop his outlook, his conduct, his philosophy, that all led to very, very poor decisions, one after another, that resulted in just chaos and devastation. The first responders that showed up on this scene were met with young men bleeding and dying and facing the final moments of their life potentially, both from being run over and shot And of course, Alex, who had little chance of survival. Very, very, very serious. And so we believe that the outcome here is appropriate. As to the full extent, we believe that it is the demand of the state that things change in this defendant, or the full measure should be, of the sentence should be served.
Thank you. Does the state want to make any comments on restitution now or in a few moments?
I think we finalized that number, and so it's been submitted.
Has the defense seen that?
I have not, Your Honor.
Let me see if it shows up in the record. Okay, so
We could leave that open for 30 days for objection, Your Honor.
the figure that's been represented as of a few days ago is $39,682.40. So consider that. It's broken down, but I'll allow you to review that, Mr. Stravinsky.
Yes, Your Honor, thank you. We just have some time to respond.
Very good. Okay, what's the defense's recommendation?
Thank you, Your Honor. Now, this was a negotiating resolution, and sometimes when we deal with mediation, especially, it kind of goes behind the closed doors by itself. It's a sealed proceeding, but there was definitely a serious work that went into negotiation, to the mediation. When we started negotiating this case and using the mediator to go through all the details and discuss all the elements of the crime, all dynamic with all the victims involved. We also, in the background, we were also thinking about the sentencing criteria, the objectives of the punishment, the two-wheel case. But when it comes to this case, I can say that there was no premeditation. When it comes to the actual events here, Mr. Perkins did not go to the school with premeditation, with intent to kill anybody. Everything is foreseeable in hindsight. After reflection, Gabe knows that his decision was wrong, and he never wanted that to happen. This will follow him forever. He understands in hindsight that he might have made the wrong decision, series of decisions. He understands that he took a life that night. And that changed many more lives. He's here to take accountability for his actions that were born out of fear and skewed perception, not out of any kind of malice. Since I took over this case, he wanted to take, basically, he was looking at this, he wanted to take responsibility. That's somebody who was 18 years old when this happened. Since he was 18, he's been in custody this whole time. But that's somebody who's had to really mature really fast, was facing with a life situation that he caused as well. But he wanted to take responsibility. He didn't want to put anybody through the trial process. And this will, going to this mediation, really, we're talking about a very, very serious, as far as sending a message to anybody, or as far as any kind of message to the message to the community or anything like that. I'm sorry, Your Honor.
To who?
I'm sorry, Judge. This is not. I'm just doing this off.
It happens.
If he doesn't work on himself, if he doesn't improve himself, if he doesn't do anything, go in custody, he's facing 40 years in prison. that shows that but what this kind of plea agreement gives him a chance is to actually work on improving himself, doing everything possible to rehabilitate, doing everything possible while he is in custody to make sure that really anyone who knows Gabe Perkins' life story will see that this is not something they should be doing. Saying if he had to do this again, he would just stay home. If he had to do it again, he would just stay home, watch the game, not respond. But unfortunately, we can't go back and redo things. He'll have many years to sit there and in Idaho, that's the punishment. The loss of freedom is the punishment that we have. And he's taking that punishment. It gives him a chance to hopefully go in front of the parole commission at some point in the future and show them that he's capable of being in the community, he's capable of being supervised while he's out. But again, that's going to be all up to him. So, Your Honor, this plea agreement was not done lightly. I was asking the court, and I just kind of remind the court. So, count one is that's the voluntary manslaughter, and we're adding the deadly weapons enhancement. So, 17 years fixed plus 13 indeterminate. Count two is aggravated battery, 0 fixed, 10 indeterminate, consecutive to count one. So that gives 40 years total max if parole commission doesn't grant him his parole.
You said 0 to 10.
0 to 10, and that's because it's going to start running after the sentence on the first case is done, on the first count is done, and then leaving the scene. That's a 5-year maximum, and that's just going to be concurrent with count one. So that's the agreement, Your Honor. Again, this young man who just turned 18 when the whole thing went down, he's shown a huge sign of maturity to understand that there are consequences for his actions and being mature enough to accept those consequences. Obviously, he's going to be working really hard to prove to himself and to society that he's capable of getting out eventually. But he's remorseful and he's really sorry. No words can ever describe how devastated he is for what happened that night. Thank you, Your Honor.
Thank you, counsel. Mr. Neal, any rebuttal comment?
No.
Okay, thank you. Mr. Perkins, are you interested in making a statement?
Yes, Your Honor.
You may do so.
Yeah, I'll just come down. I never thought a night like that night would ever occur. It has plagued and haunted me since it happened. Every time I try to sleep, it replays in my head. I don't sleep much anymore, really. I've thought of so many ways where I could have changed the outcome or just totally avoided what happened. I wish I could take the night back, but I can't. It's out of my control. I'm extremely sorry to all the victims' families, and their friends. My actions were never fueled by anger, hatred, or malice. They were just fueled by fear. I was simply scared. It was never meant to go that far. That's just all I wrote. So, thank you.
Are you fully satisfied with the representation of your counsel?
Yes, Your Honor.
Counsel, is there any legal reason why the court should not pronounce sentence?
No, Your Honor.
All right, well, very well. Let me share then in response to the things that the court has heard and studied in preparation for today's sentencing. I think I will begin with just a quick review of what that includes. It includes the pre-sentence investigation report. and the addendum, the accompanying materials associated with that report, and the court has taken notes during today's proceeding, including counsel's arguments and those that have testified today. Mr. Perkins, there are 4 objectives that the court is required to consider when fashioning a sentence, and they include protection of society, deterrence to you and to others, rehabilitation and punishment for the wrongdoing. Each of these objectives are critically important to the outcome of the sentence. I want you to know that. Most prominent, of course, is protection of society, with the results and the harm and the loss of life that has occurred as a result of the actions that were taking place on that day. I have a few comments to make about where we end up in this agreement, but I think I'll first turn to a few remarks that the court has, listening to those that have come to the courtroom today and provided statements. I do want everyone to know that's here, and there are many faces on both sides of this courtroom that I recognize over the course of many proceedings. I know that it has taken a significant amount of time to bring us to this point. I regret that insofar as much as I have an experience of knowing that these kinds of things take some time. The parties I know work very diligently to come to a resolution, and if I could have delivered this resolution in any way earlier, I would do that, because I know how painful it is to come through these courtroom doors and hear that the case has been delayed for various reasons. So I express my sympathy with regards to that, but I also want you to know that I believe the attorneys have been very diligent and worked hard in their respective interests to bring justice to this matter at this time. But I do recognize many of you for coming to court, and I thank you for that. Mr. Barber uses the term nightmare, and I think that's a very descriptive way to express the feelings. And it's one of the worst kind, he says, and one that never awakens from. And I recognize that there is that expression of difficulty to move on. I know in the law we use the term resolution. I think that was used by Mr. Neal in his opening remarks, and I know what he references. I know that others do, but in a matter such as this, there is, in many respects, no resolution. And that's difficult. And that nightmare continues. I hope that there is an avenue for some measure of healing. One of the things that struck me as I listened to Brother Chris Stewart was, as I look out upon those that are in the courtroom today, there are children in this courtroom, and that saddens me. And Mr. Neal's description of the ripple effect that has taken place and will continue really indefinitely includes young people who have a difficult time making sense of any of this, let alone adults. So I was affected and touched by what he had to say. And Sister Annalisa, you're a remarkable person to express forgiveness. That is incredible, and I hope that there is an avenue for you and everyone in this courtroom, including Mr. Perkins' loved ones and family, to find a way to that peace that you're yearning for and longing for. Mr. Johnson, what strikes me in his statement, which I think we can all agree, this occurred, and I quote, over nothing. And isn't that true? That these months following the event, trying to make sense of it in the context of all things, realized that this argument, this dispute, began over literally nothing. And yet we have this so tragic and horrible outcome. Those questions that exist in his mind, as I'm sure he's expressing the same feelings of so many others, is the whys. Why did this happen? I'm sad to say that I don't think those things are ever known or answered or delivered, and it's an unfortunate thing. What this court saw in review of the materials was complete chaos at what transpired at Compass Academy. Individuals who were completely out of control, and what I would suggest to you is that out of control is now imposed upon you by absolute control. The parties have negotiated an outcome which determines complete control, loss of liberty in your life in some form or measurement for the next 40 years. And that's because of how out of control things were and you were that night. I want to make a few comments about the agreement itself. The court will follow what the parties have negotiated. I was in the courthouse when the parties were engaged in their discussions. This court has engaged in many mediations for cases such as this. I know the work that goes into them. I know the difficulty that exists, and even sometimes the feelings as you're leaving the courthouse after a resolution of regret that an agreement has been struck. And I, as a sentencing judge, recognize that there are interests involved that can't be overlooked. And those are sought and obtained, and in my review, with the assistance of a very experienced senior judge, that those were met and satisfied, but it certainly does not bring the closure that everyone longs for. In the legal sense, it brings some measure of resolution, but I hope it does provide an avenue for healing. What we know it provides an avenue for, which is the objective, and it's this court's responsibility to impose, is accountability. That Mr. Perkins is one of those mitigating factors that the court places in a category of consideration to follow an agreement, is your willingness to say, yes, I am guilty of these offenses. I am pleased that you took the opportunity to express remorse. I would have been very disappointed if you had not done that. I think it's important that you do that for those that are here and whose lives have been torn apart. I think it's important for you to express that for your loved ones and even for your own path to accountability. I accept Mr. Stavinsky's conclusion that there had not been that period of premeditation. The court believes, however, that charge exists to bring the parties to the voluntary manslaughter. Another mitigating point is not a significant amount of criminal history, although you're a young man, and I appreciate the maturity that would have had to have occurred at the very moment that you were arrested and continues through this whole experience today. So with all of these considerations, and lastly, let me just comment upon your description of being haunted. That's a word that this court has heard many times, mostly from victims of crime who are haunted, and it's interesting to hear that you say that you are haunted, and I believe that it's likely true, as you have images as so well described by Mr. Johnson, giving everyone in this courtroom insight into what it would have been like to have been there that night. That is a nightmare, and it's one that I think will continue to haunt you. I know that it will haunt others. I accept the terms that the parties have negotiated and will sentence the defendant as follows. On count 1, voluntary manslaughter, the court will impose, subject to the enhancement that accompanies that charge, 17 years fixed with 13 years of indeterminate time. Count 2 is the aggravated battery, 0 years fixed with 10 years indeterminate. That will run consecutively to count 1. Count 3 is leaving the scene of an accident, 5 years fixed with it running concurrently. Restitution will be held open for a reasonable amount of time for the defense to review and the state to also review its records to see if it would be increased in any way. The court will impose the maximum amount of fine on count 1 of $15,000, and similarly count 2 will carry a $15,000 fine on count 2. Mr. Perkins, do you have any question regarding the sentence?
I do not, Your Honor.
You have the right to appeal this judgment within 42 days. Post-conviction relief expires a year after that, and a Rule 35 in 120 days, and your attorneys will visit with you about whether any of those remedies have any applicability. Okay? Thank you all again for your attendance. This court is in recess.
All right.
17.